doesn't so much summarise the contents of JS2 as the use to which it was put. JS2 was put by Corporal Brown.
Well, yes, but in one sense that's of some importance, in the sense that it demonstrates in one sense how important JS2, because JS2 was raw data which was then presented by Corporal Brown through effectively his own interpretation of it. So that's why the summary is there, because he was effectively presenting the evidence.
Where do we find a summary of the contents?
I'm not sure there's a... Sorry, I think it's fair to say one doesn't. My Lord done a trail to find out exactly what was on JS2, and I've recently seen what appears to be JS2, which entirely fits the summing up. But I can tell you what it contains now, or wait until I begin.
It would be helpful for us to know what it contains.
Yes, and perhaps Mr. Sudley, if I say what I believe it contains, Mr. Sudley can then take instructions. My Lord, what JS2 was the disk, as I understand it, and then from that disk, Corporal Brown drew up a spreadsheet, various spreadsheets. Now, the first spreadsheet consisted of texts. Second was a spreadsheet of phone calls. And it was drawn up, these spreadsheets were drawn up from 4 telephone numbers. That is to say, Mr. Child's phone number, the deceased's phone number, Mr. Palmer's phone number, and Mr. Campbell's phone number. So they were the only phone numbers which were the subject of JS2, A, in relation to texts, B, in relation to calls. Now, as far as the texts were concerned, what they consisted of was the following. Text between the deceased and his girlfriend on the 14th and 16th of August 2011. 16th of August 2011, that being the day of the killing, we say. Those texts are summarised in the summing up at E4788 to E4791, and we also summarise them in our case at 6227 hours 40 and 41. But essentially, they're the ones where the deceased is saying, I'm getting more worried. The second set of texts are to and from Palmer between the 8th and the 12th of August 2011. But they appear to be of no importance at all. They don't appear to be referred to in the summing up. They were read out to the jury, but they don't add anything. The third set of texts were those from and to Sean Campbell, which are to an extent incriminating, and they are referred to in the summing up. They suggest that on the day of the killing, but before the killing, Campbell knew that the deceased was going to be executed. He had to die. And they suggest that after the killing, he knew the killing had taken place and they needed to get away. And you can see a summary of those texts in summing up at 4989 to 4991. That's where they're set out and explained. And importantly, my lords, it is a point you may have wondered, what about the other defendants? Now, it does seem as if texts were collected from the other defendants' phones, but they, after the voir dire, were excluded. And that, therefore, means there are no texts passing from St. John, passing to and from St. John, or Jones, or Shane Williams. They were originally in the original exhibit before it got to the jury, but by the time it got to the jury, those texts were all gone. As far as the call of telephone logs is concerned, that ran from the 10th to the 17th of August 2021, and what they did was indicate the nearest cell site which picked up the respective calls. And they did show, again, when Palmer was receiving or making a call, likewise Campbell, likewise the deceased, and likewise Chow. I should say, and Chow. There don't appear to have been, as far as I can make out, any texts from Chow. So that's the nature of JS2. But the only really incriminating material in
What would your business do with the power of prediction? For years, Tango has studied customer shopping patterns.
JS2, as such, are the text messages passing to and from Campbell shortly before and shortly after the killing. I say incriminating, of course, those between the girlfriend and the deceased are incriminating, but they are not from Campbell, they're from the deceased's phone. I think I've given you the references where you can find it all in the summing up. We don't summarize all of it in the case, but we do summarize quite a bit of it in our case. We have tried to get hold of exhibit, I think it was exhibit 10. There are some difficulties getting hold of exhibit 10, that's all I can say. I have seen what we believe to be exhibit 10 in relation to the texts. I was handed another exhibit, which plainly was the unedited version in relation to telephone calls. So we haven't put that in. But we can make available what I believe to be the exhibit in relation to text messages.
And did the judge sum up in relation to the cell site evidence?
No, not really, apart from what you just showed. I think it's fair to say not much appears to turn on the cell site evidence. I will address you later as to why I say very little turn on it.
Thank you.
Can I say, from the appellant's point of view, one of the reasons for, in one sense, perhaps not drilling down into the details of JS2 was for two reasons. Firstly, the clear position of the Crown, as I say, which is to rely on JS2 as being part of the reason why they argue that proviso should be applied in relation to the jury. That, we would submit, is a clear indication of the potential importance of JS2. The other is that, as I've already indicated, the clear indication is that this was a case where, in particular, the only direct witness, Mr. Chow, was someone who appears to have been regarded as unreliable by the jury on the basis of, given the acquittal I've already drawn attention to. And that demonstrates the potential importance of the technological evidence. Can I go back, though, to the point that the reason I was talking about what was being argued below and drawing attention to the fact that there was no debate about the, it's clear, it was accepted that there was an argument that JS2 should be not admitted in light of the Charter, and in particular the breach of the Charter. The reason I draw attention to that is because effectively what the Crown does is argue that what is now being put before this court is a new point. That's a part of the Crown's response. In summary, we don't accept that is right for these reasons. Firstly, as I've already indicated, it is clear that the issue of a breach of the Charter was before the trial judge. That's accepted. Now, the arguments may be different, more nuanced, may rely on authorities that weren't being raised at trial, but that doesn't mean.
Recordings just got better. Hey, it's Dana from StreamYard. I'm so excited to announce that local
that the issue wasn't before the trial. Linked to that, clearly the Court of Appeal's question that relates to this matter is premised on there having been a breach of the Charter. All the way through, and I can give you the references in a moment, all the way through, from trial court up to Court of Appeal, the way in which this matter has been dealt with is on the basis that it appears to be accepted that there is an issue in relation to the Charter, and the question was, what implications should that have? And that's why the Court of Appeal then, we would say properly, referred a question about the approach that should be adopted by trial courts to evidence that's obtained in breach of the Charter. And so we don't accept that this is a case where we're prohibited in some way from arguing what we're arguing. We're arguing the same issue that was raised at both courts below, albeit perhaps slightly more nuanced. Now, in terms of the nature of the breach, because our case accepts that there is no automatic rule that a breach of the Charter will inevitably lead to exclusion of evidence. It is a more nuanced argument than that. It's important in one sense to be aware of the nature of the breach. And in one sense, the starting point in our submission in relation to that has to be the legislation, the section 16. Yeah, section 16 of the Interception of Communications Act, which is at 6277, the relevant passage, section 16, the Act, and that is section 16.2, and it is not a complex piece of legislation, which is probably a virtue. It requires a designated person to make a request, and it requires an authorised officer to receive the material. Designated person is defined. Section 16, page 6276, the preceding page. Designated person means someone who's prescribed by the minister. Section 2 defines what is an authorised person, authorised officer, and that's at 6257. It's a number of specified officers within law enforcement. Two other features of this legislation that are worth noting. Firstly, if you go to 6279, section 17 links compliance with section 16 to admissibility of evidence. And section 4 demonstrates in one sense that what this act is about, consistent with the terms that of the legislation that I've taken you to already, because section 4 is concerned with warrants essentially for interceptions, and what that demonstrates in my submission is what this act is about prescribing.
I was 17 years old when I took over my family's small farm. Today, we farm over 15,000 acres.
Safeguards in circumstances where what the Jamaican state is and what Jamaican law enforcement in particular is seeking to do is interfere significantly with the rights of individuals to privacy. So it is a piece of legislation that's intended to put safeguards in place, and clearly requiring officers of sufficient seniority essentially to authorise gathering of data is an important part of seeking protection, of protecting the rights of privacy. Now, in this case, Corporal Brown was the officer who made the request, as I'm sure you've picked up. He said expressly that he was at page 1631 of the bundle, line 19. He said expressly that he was familiar with the Act, and that was hardly surprising because his whole role, as he gave, which he, according to him, when he gave evidence, was essentially to make requests under this Act, and you see that at 1574. Line 5 on line 5 to 13. Now there's been an issue about what he was cross-examined about, and that's raised by the Crown in their case. He was cross-examined about his knowledge and compliance with section 16. If you go to 1632 in the bundle, he expressly said that it was from line 24 on until line 4 the following page, that he knew that there needed to be compliance with section 16, and he believed that the notice that had been sent to Digicel complied with that. Now, that is in one sense a slightly surprising answer, given what he says almost immediately afterwards, because he was then cross-examined about the need for a designated person. And if you go to 1635 from the top of the page, he recognises that section 16 requires a designated person. He recognises that he wasn't designated. He says that twice, in fact. I'll just give you the reference. He also says it at page 1641. And so on the face of it...
He's not designated, but he is authorised to receive.
He claims he's authorised to receive. I think it's the Court of Appeal found he wasn't authorised to receive, but he...
The judge accepted he was in the voir dire.
Well, I'm not sure the judge actually expressly ruled on that, but certainly the Court of Appeal was of the opinion by the time that they'd got no evidence that he was an authorised person.
Well, did they get other evidence other than that was produced in the voir dire before the judge, where this matter was fully explored?
Well, the problem is, I mean, if you look at the evidence, there's his assertion that he's an authorised person, but he clearly doesn't come within the terms of the legislation, and there's no evidence there was no evidence that I can find that indicates how he gets authority when the terms of the legislation are clear. Similarly, that's why I assume the Court of Appeal said what it said, because on the face of it, it's difficult. Although that was his answer, he clearly doesn't come within the definition, and there's no evidence to explain how authority was in fact given. So that's why I think the Court of Appeal, I don't know, slightly speculating there, but that would be a good reason for the Court of Appeal to say what it said. But it may not matter, because in one sense, there was non-compliance. There clearly was nobody disputes there was non-compliance, and that may matter to some extent. I suppose the way in which it may matter is it may go to how serious the breach was. But I mean, the clear problem here in our submission is Corporal Brown is saying, and I'll give what I understand may be his answer to this in a moment, just take you to it. Corporal Brown is saying, I know about section 16. I know you need a designated officer. I know I'm not a designated officer, effectively. So on the face of it, that's a problem. Now, what he does suggest is, if you go to 1643, and this is all just to make clear in the course of cross-examination, which is clearly intended, we would submit, to determine why this breach occurs, and 1643/20.
Are you a STEM professional and are looking to apply for U.S. permanent residency? Then stay tuned.
22, line 22, not 2022. Corporal Brown indicates that there may have been, that others may have been designated.
We named it.
He names them, yes.
922.
Yes. He names two officers, ASP Pascoe and Inspector Williams, as potentially others who may have been designated. But he accepted, if you go on to 1646, that he did not know whether or not they'd had the benefit of an affirmative resolution. And you will remember that the terms of the legislation are clear, that you need an affirmative resolution. And he accepted that he, in one sense, he needed to rely on them having that authority, because he knew, he accepts at 1652 that he knew the request was not from a minister. And so you have on the face of it Corporal Brown saying, I know what the legal obligations were, but essentially I've assumed compliance with them. And you see that reference to assumption, that's his language, not mine, essentially, at 1653, lines 13 and 14. And that, in our submission, suggests that this isn't, that there is at least a degree of negligence essentially here, in the sense that this is someone who understands it's his job, he understands that he is subject to legal obligations. He doesn't check effectively compliance with those legal obligations.
Doesn't he at some point say that advice had been taken?
That's, I think, if I remember rightly, there is a reference to that. I think that may be the Digicel witness from memory. I'd have to double check that, because but I think it was there was reference to advice, but I think that was the Digicel witness.
We can come back to that.
Yes, but my Leonard Junior has confirmed my memory.
Thank you very much.
I'm always just a little cautious about saying things on my feet, but I think that's right. Yeah. It was the Digicel witness. And of course, the other factor here, which is something the Court of Appeal highlights, is that the Court of Appeal had already, by this stage, by the stage of the investigation, not the stage of the trial, but by the stage of the investigation, made clear that there was that what the terms of the ICA were, the legislation were, in a judgment called Phipps. And the Court of Appeal point this out at 137. So it wasn't as though, I mean, the problem with taking advice was that that might have explained an initial failure to comply. But if you look at 137, which is 5828, they highlight the fact that Phipps demonstrated a flawed approach similar to that adopted by Corporal Brown. And that raises the question of, in one sense, even if Corporal Brown is effectively the relatively low-ranking officer who perhaps hasn't picked up the latest Court of Appeal judgment, why action wasn't taken by those in command of him. And that's one of the things that the Irish Supreme Court have emphasised when looking at responsibility for compliance with constitutional rights. It's not simply the person who's on the ground that you need to worry about, it's what happens higher up the chain and why the system essentially was operating the way it was. I mean, this was a situation where the Jamaican police had been told in Phipps, your process is wrong. And yet there was no evidence essentially explaining how you then had Corporal Brown making the same mistake or a very similar mistake. Now, the Crown argue that it wasn't put effectively that the police, or indeed Digicel, acted negligently. A few things about that. Firstly, it was the Court of Appeal themselves who essentially pointed out the non-compliance with Phipps and the issues that arose in relation to that. Secondly, but perhaps more importantly, the word negligent wasn't used in cross-examination. I accept that. I can't find any reference to that. but the questioning clearly focused on the actions, whether effectively the actions of the police demonstrated that they were disregarding their legal obligations. What the questioning was focused on was how Corporal Brown had been in this position when the provisions were clear. Thirdly, in any event, I'm going to come on to make the point, based on case law, particularly Mohammed, that the burden was essentially on the prosecution to show to explain essentially why there'd been non-compliance with the law. And it should be noted, just one reference in relation to that is of some significance. If you, at 1966,
there's no reason to think, had Corporal Brown been designated and authorised, there's no reason to think that this material would not have been provided. There was no substantive reason why that material wouldn't be provided, is there? I'm just asking.
Well, the way in my submission to approach that, and it is, and can I, in one sense, take issue with the way the question's phrased, rather than, and I will answer it directly if I can as well in a moment, but I'd take issue with the question. In our submission, if the Crown is going to say it doesn't make a difference, it has to adduce evidence of that. Now, in a case like this, the role of the Minister and anyone who's been designated by the Minister is important, because it is essentially intended to act as a check. It's intended to ensure that the police can justify a substantial interference with privacy rights. Now, the way in which you potentially would have been potentially open to the Crown to call, for example, the Minister or someone they designated and say, who could have said, I'm the designated person, I've looked at this, there was a good reason for making that material wasn't produced. So one simply doesn't know that. So
the investigation of a very serious criminal offence targeted at people alleged to have been involved in that very serious criminal offence would have justified disclosure of this material?
Well, you need a sufficient, I mean, you can't, because of the privacy material, you can't
you don't
just
accept.
I don't accept as a matter of principle that you need enough, you need a good basis for believing that evidence may be relevant. Of course, I mean, the whole point of the legislation, it seems, we would submit, is to strike a balance. So it's to recognise that there may be circumstances in which the evidence will be of value and to enable a route by which it can be obtained, but restrict those circumstances by putting checks in place. So that's why we would submit that on the material available, one simply doesn't know whether a designated person would have. And just one.
Whether a designated person would have made the application.
Sorry, whether the designated person would have authorised it. Yes.
Well, the designated person doesn't authorise the notice to.
Yes, because that's in one sense the author. My lady was asking me the point about designated officer and authorised officer, and in one sense, the designated officer, in a very real sense, the designated officer is the more important safeguard, because he or she is the person who gives authority, and they're the one who needs to ensure that there's a sufficient justification. I assume the reason why an authorised officer is needed to receive the material is to make sure its privacy is substantively protected.
Yes.
But the authority is given by the designated officer, and they're the person, in one sense, who is perhaps the more important safeguard.
How do you square that with your submission about the importance of the material?
Well, when we look at the material now, we know that the material found was important. But that doesn't mean at the time the application was made, there was justification, because obviously when making the application, you don't know what there's, as far as I'm aware, there was no reason to believe that there was knowledge essentially of what that material would show. That doesn't mean it wasn't justified making the application. It may be that the officer had sufficient information to demonstrate that there was reason to believe there were telephone communications. But we now know the relevance of that material. The question that we don't know in my submission is whether a designated officer, knowing what was known at the time the request was made, would have been satisfied that the justification outweighed the interference with privacy. And that's an important safeguard. That's clearly why the requirement for a designated officer exists. It's to stop fishing expeditions. It's to ensure that there is a proper basis for making the application. So that's, can I just draw attention to one other reference in the material about this, which is going back to the point I made about the need to, in one sense, have material about the system and how Corporal Brown wasn't effectively given clear directions as to what he needed to do with. If you go to 1966,
We know you're striving to create the perfect office experience for your employees and guests, one that enables productivity, collaboration.
Of the authority, not of the authorities, of the electronic bundle, line 10, there is a submission there made by the Crown, albeit one that's made apparently without an evidential basis expressly for it, because no evidence was called in relation from a commanding officer, as far as I can see. But in support of the submission that Corporal Brown was acting in good faith, the reference was essentially that this procedure had been dictated to him. Now, that raises a question. That's why, in one sense, we submit. It's striking that there was no evidence about the command structure, how this system had been allowed to remain in place, despite the clear terms of Section 16, and despite the clear terms of Section 16, and despite the judgment of the Court of Appeal. And the Crown makes the point, or argues, essentially, that the defence didn't argue that Corporal Brown's acts were, well, it didn't challenge the submission that Corporal Brown's actions were in good faith. Firstly, we would submit that making whether or not the actions were in good faith sets up a false dichotomy. Essentially, there isn't in our submission a simple distinction between actions that are in bad faith and all other actions. The reality is that breaches of constitutional rights, such as those in this case, fall on a spectrum. For example, somebody can act in good faith but still be negligent by simply not paying sufficient attention to their legal obligations. They can act in good faith, but there can be a failure by those in command of them. Secondly, the submission that is highlighted by the Crown about good faith was essentially an argument that good faith was irrelevant to the breach of the legislation. It wasn't essentially a submission about how the court should approach the consequences of the breach. In terms of the consequences of the breach, the submissions, as I say, were pretty clear that there was an argument, essentially, that there'd been a breach of the Charter and that should lead to the exclusion of the evidence. And the trial judge recognised the significance of arguments about the breach of the Charter. The charge, if you go to 2237, bottom of the page, lines 23, the trial judge indicated he recognised the force of the arguments there'd been a breach of the charter, apparently accepting that there'd been a breach of the charter. But at 2240, at lines 13 to 20, essentially, he cited Khan, and in particular, 2240, he cited Phipps, which is the Jamaican Court of Appeal Authority, which indicates that...
I think he cites Khan on 2240.
224, well, right at the bottom he cites Khan. He cites Phipps before Khan. Sorry,
sorry.
I was misreading my own notes. I'd gone to 2241, and that's what was slightly confusing.
Yes, I see. 2239.
Yeah, he cites Phipps. He then cites Khan. And what he does at line 20, rather, at 2241, is he indicates that essentially that the breach of the convention does not mean the trial it is unfair. And he, applying Phipps, if you then go over to 2242, line 17 onwards, he indicates that the issue is relevance and not how the material was obtained. So on the face of it, particularly at 2242, what he's doing, applying Phipps, which itself goes back to Khan, which we submit is the wrong approach.
You don't have to be at a point in your life where you feel like you're hanging on by a thread to go and speak with a therapist. As a licensed therapist, I often hear people think that therapy is reserved solely for those who
directs himself that the only issue really is the relevance of the material. It doesn't matter that it was obtained in breach of the charter. And that's, we would submit, the approach that was adopted by the Court of Appeal as well. If you go to 5833,
Sorry,
page 5833, 147. You see the application of King and Phipps. And then if you go on to 5836, top of the page, which is the end of paragraph 150, the judge adopted essentially the correct approach. The indication is that the judge adopted the correct approach, applying King, and that led to the rejection of the arguments about the Constitution. And so the Court of Appeal proceeded on the basis that there was a constitutional issue raised, a charter issue raised, but rejected it given the application of King and given the application of Phipps. We submit that is a misdirection, and that had this been approached properly, given the evidence I've taken you to, and in particular the absence of evidence to explain essentially the how it was that Corporal Brown, despite apparently being aware of his legal obligations, didn't ensure that there'd been compliance with those legal obligations. We submit that in those circumstances that the evidence would have been material, that would have been excluded. Now, the reason we submit it should have been excluded is this. Firstly, it's important to start with the Constitution and the Charter. And the Charter in our submission, the reason for that is that we submit, obviously, that it's important to look at what the Charter itself says to see what approach essentially should be adopted to breaches of it. And the Charter is electronic bundle 16 sorry, 6248.
6248.
Thank you.
Just before you move on to this, are you submitting that the approach in Phipps and King is that one is not concerned at all with how the evidence is obtained, that there's no discretion?
I'm submitting this, that King and Phipps, certainly the way the judge understood this, and I wouldn't disagree with this, is concerned ultimately with the impact on the fairness of the proceedings, not how the material was obtained. Now, there are circumstances possibly where how the material was obtained may have an impact on fairness. I mean, if you torture someone, that would probably have an impact on fairness. But the critical difference between that and Muhammad, which is what the approach of this court to written constitutions, is that what Muhammad does in our submission is recognise that there is a significance in a state incorporating rights within a written constitution, effectively elevating those rights as being ones that have to be given particular weight, and that even in circumstances where perhaps there isn't an issue about fairness, what the court needs to do is balance the unfairness, sorry, not balance the unfairness, balance the nature of the breach against the interests of the state in admitting the material. And so the fact of a breach has to be given weight. And Muhammad recognises that that is a different approach to King. He expressly says that.
So do you not take into account the fairness, the impact on fairness as part of that balancing exercise at all? You just weigh breach as against interests of the state in disclosing?
Well, you can't, obviously, because you have a constitutional right. Now, I'm not arguing you can have an unfair trial, but the nature of but what you can have in my submission, that I'm not saying you wouldn't take account of that. What you can have is a situation where the nature of the breach is sufficient on its own to justify exclusion, because the nature of the
yes,
breach...
no, I understand that, but I thought in answer to my Lord's question, you were saying you don't...
This report just dropped and showcases 70 plus data points from how the e-commerce and fulfillment industries have performed in 2023.
Any longer as a result of the charter have regard to the impact on the fairness of the trial?
Well, can I just slightly modify my answer? I was referring to Muhammad, and we obviously go one step further, arguably, by referring to the Irish case law. So we would potentially go a little further, and I'll come on to the Irish case law in a moment. But before I do, what I was trying to do, just to be completely clear, is draw a distinction between the King and Phipps approach, which is simply focused on the fairness of the trial and doesn't necessarily give any weight to the significance of the breach, and the Muhammad case, which does give weight, and very real weight, to the significance of a breach because of the importance of a written constitution. If I suggested that fairness wasn't a factor, then that was lazy language on my part.
So you accept it is a factor?
Yes. It has to be, yes. I would accept under Muhammad it has to be a factor. Yes. Yes, but as yes, just to re-emphasise though, the critical point about the Muhammad case law is it gives weight to the inherent significance of a breach of the Constitution, and so it can lead to exclusion simply on the basis that there is a need to protect and vindicate constitutional rights, and that's the distinction we would draw. Going to the Charter, That's, as I think I indicated, 6248. I should say we've used this unofficial version. I've had this issue before. There is, as far as we've ever been able to discover, there is no official version of the charter, of the amended constitution, including the charter. So you can find the legislation that includes the amendments to add the charter. You can get a version of the constitution that doesn't include the charter. This is the only version that we've ever been able to discover of the fully amended constitution. That's why we refer to it, but it is formally from an unofficial source. There doesn't appear to be an official source which is for the constitution fully updated. The key provisions, firstly, to draw attention to, can I draw attention to section 13(1)(a) and C first? They are, well, the whole of section 13(1), really. The first point I wish to make is that section 13(1)(a) imposes a positive duty on the state to promote observance of human rights. Now, that is, in our submission, a demanding standard, and it's not. It goes beyond a mere obligation to comply with the human rights standards contained in the Charter, and it's part of the context in which admissibility questions should be viewed. Obviously, a key way of promoting observance with human rights is to ensure that non-compliance with the Charter has consequences. 13(1)(c) I draw attention to because it demonstrates, and there are other features of the Charter that reflect this, the fact that Jamaica's approach to human rights goes beyond, in one sense, a European approach, because it applies to all persons. The obligations under the Charter apply to all people. That was, looking at the debates, a positive decision, and it demonstrates a key feature, and I'll take you to some material that makes good this submission, of the Charter, which is a desire, essentially, to enhance rights, reflecting the fact of Jamaica's independence. Section 13(2) then indicates that effectively the rights that follow in section 13 have to be complied with, save as may be demonstrably justified in a free and democratic society. And subsection B makes it clear that no organ of the state shall take action which abrogates, abridges, or infringes those rights. That's important for a couple of reasons.
I was 17 years old when I took over my family's small farm. Today, we farm over 15,000 acres.
We would submit. Firstly, it makes it clear that there is an obligation on the courts, because as an organ of the state, essentially, to ensure that those rights, the rights that are incorporated within the Charter, are not abridged. Secondly, when read then with subsection 3J Roman 3, which is about the privacy of communications, it explains why in our submission it is clear that a failure to comply with the relevant legislation, the Interception of Communications Act, is a breach of the Charter. And the reason, quite simply, is the legislature has decided effectively the limits of what are justifiable interferences with the right to privacy by imposing a procedure that needs to be gone through before there can be interferences with that right to privacy. And if an individual such as Corporal Brown goes beyond those restrictions, in our submission it becomes clear that it can't be justified essentially because as I say, the legislature has set the limits. There's a sort of analogy we draw in our written case between the point my Lord Reid made in the Osborne case about how human rights standards are often in very general terms, and it's for domestic law effectively to fill in the gaps. And that's what we say the Intersection of Communications Act does in this case. It is what fills in the gaps in a very general statement about the importance of the right to privacy. And that's why it's so important, compliance with it. And that's why in our submission it is right to it's right that the courts below proceeded on the basis that there was an interference with the right to privacy. Now, one thing I should just touch upon is that the prosecution say, well, it's absurd, I think is their language, to argue that the constitutional rights of Mr. Chow or the deceased or his girlfriend were interfered with. In our submission, firstly, the approach to waiver will become clear when I come to jury rights, and in our submission there's no suggestion of waiver. But in any event, it misses the point. The whole point about the Intersection of Communications Act is that in a modern society, clearly there is a huge amount of data held by all of us, held on all of us by people like communications companies. So there is a need for safeguards because there's no reason to believe that the material obtained was necessarily restricted to the deceased, his girlfriend, or Mr. Chow. All the indications are sort of indicated that it goes beyond that, and that's why these safeguards matter in our submission. Two other provisions worth just noting. Firstly, partly so I can avoid going back to them. Firstly, section 16 is the right to a fair trial by an independent and impartial court. Included within that, in the criminal context, at subsection 6G, is the right not to be tried in your absence. That is obviously relevant when we come to the jury issues. It does have some implications, though, for the first issue, the admissibility, because in our submission, and we made this clear in our written statement of case, there are issues that potentially arise if the state breaches constitutional rights. There are fair trial issues, not least because in one sense, the state then has an inequality of arms. It is used the powers it has.
This bobblehead is just ridiculous. And did you notice who it is? That's right, none other than the man who will make
as in an unlawful way. The other provision we draw attention to, because it was touched upon by the trial judge sort of indirectly, is if you go to section 19.4, section 19 is essentially concerned with redress. And in particular, section 19.4 recognises that although the Supreme Court may, has jurisdiction generally to deal with breaches of the Charter, a point the judge made, there is a need, because redress has to be effective, for other courts potentially to exercise their jurisdiction. That links, we would submit, to the Brandt case, which we've referred to in our statement of case, which indicates it could be an abuse of process, essentially, to go to a court like the Supreme Court in the course of criminal proceedings. And we would say that the more fundamental point is that we can make about section 19.4 is it demonstrates the importance of redress being effective. And that, in our submission, is part of the reason why it's important that in appropriate cases, evidence obtained in breach of the Charter is excluded. The Charter itself is, just to be clear, an unusual provision within the Caribbean, in the sense that, and this is recorded in a book that we've included in the authorities' page 8334, the Oxford Handbook of Caribbean Constitutions, is that Jamaica is one of only 3 countries that has made significant changes to its independence constitution. In Trinidad, they are described as being cosmetic. In Guyana, they were concerned with the presidency being introduced. But in Jamaica, obviously, they were focused on human rights, and that's important. Jamaica is, as far as we can see, the only Caribbean country that has used independence essentially as a way to enhance human rights. And one sees the fact it was intended to enhance human rights in the Joint Select Committee report that led to the Constitution. If you go to 8213, this is the final report. There is a lengthy history, and we've set it out in our written statement of case. I'm not going to take you to it, and we've included the materials about it. There's a lengthy history of debate. It was a particularly long debate process. But the final report of the Parliamentary Joint Select Committee, it helps in 2 ways. Firstly, it makes it clear at 8213 that the Constitution was influenced by other written constitutions, and that's partly why we submit we're entitled, for example, to refer to the Irish Constitution, because it is a written constitution with similar features. Clearly, part of the aim of this process was to reflect developments in other states. More importantly, though, in one sense, one of the recommendations of the committee, which was adopted when the legislation passed through the Jamaican Parliament, it is set out at 8211, and that is that there should be a limited preamble reflecting the historic background, essentially, to the legislation, but most importantly, making it clear that what the legislation, the Charter was intended to do was produce, and I use these words because they're found in the preamble, was produce more comprehensive and effective protection of fundamental rights. So the clear intention of the Jamaican legislature when adopting the Charter was to enhance human rights. And that's reflected, I think, given time, I'm not going to take you to it, but we would refer you to the judgment of the Chief Justice of Jamaica in the Robinson case, first instance, but it is a judgment of the Chief Justice reviewing the significance of the adoption of the Charter, and that's particularly paragraph 203. Sorry, it's page, yes, sorry, I should have given you the page. It's 6472, particularly, in fact, paragraph 6475N. And so there has been reference, it's not my term that I came up with, as to how the Charter is a Jamaicanized version of human rights, or is a Jamaicanized approach to human rights. That's the context in which one should look at Muhammad. And Muhammad is in one sense, perhaps the least we ask for, or the least we argue for. In our submission, it reflects the current approach of this court to written constitutions. Now, Muhammad starts at 6301, and it was concerned with a breach. You see it at para 11, it was concerned with a breach of constitutional rights resulting from the admission of a statement. Now, my learned friend says, essentially, just to address one point, that there is a difference, because what happened was in Muhammad was a breach of an express provision in the Constitution. He suggests there's a distinction here, but in our submission, nothing in this judgment indicates that there are different types of rights protected by written constitutions.
Have you been suffering from the after effects of a car crash? The good news is you're still entitled to a 5 or 6-figure settlement.
The fact of the matter is either there was a breach of the Constitution here or there wasn't. And as the question is, as the issue is identified at paragraph 11, the issue in Mohammed was the consequences. And the approach of the Court of Appeal, having rejected an argument based on US case law, essentially that there was an absolute exclusion. The approach of the Privy Council, essentially having reviewed a number of other judgments of a number of other courts considering written constitutions, is at 28 and 29 of the judgment, which is 6308. Couple of points that, well, just to highlight a few things. Firstly, and it's important given the facts of this case not to lose sight of this. At the top half of paragraph 28, the court makes it clear that if there's a dispute about facts, the burden is on the prosecution, essentially. And that it was said to expressly include, for example, whether there was deliberate infringement of the rights. And that's important in our submission. Firstly, it clearly reflects the criminal standard of proof, but it does in our submission demonstrate in a case like this that if the Crown is going to say, for example, we could have obtained this material in any event, it needs to demonstrate that by evidence, essentially, as to from the relevant designated people. It also needs to explain what happened in relation to leadership in this case. Now, in terms of the test to be applied, the court notes, and I accept it expressly says this is in the context of Trinidad and Tobago, and that's important in one sense because obviously each constitution will have its own features, and as I've already indicated, Jamaica has this unusual feature of having adopted a deliberate, rather having rejected or amended the independent constitution and replaced that with a constitution which was intended to reflect a lengthy debate that had taken place within Jamaica. But it said in the context of Trinidad and Tobago, the approach is neither prima facie exclusionary nor prima facie inclusionary, but there is a need to weigh the interests of the community against the interests of the individual who's been exposed to an illegal invasion of their rights. Now, that is the context of then what follows in paragraph 29, and paragraph 29 is quite clearly a rejection of the King approach on the basis that there was a distinction to be drawn between constitutional rights and common law rights. And the reason it does that is because it indicates that it's of fundamental importance that a right is important enough to be contained within the Constitution, and constitutionality has to be given meaning. It shouldn't be meaningless. But it recognises that it's also necessary to consider the nature of the guarantee and the nature of the breach. The ultimate conclusion quite clearly is towards the bottom of the page, where the court talks about breach of a constitutional right being a cogent factor militating in favour of the exclusion of the confession. And that's the critical point in one sense. Going back to the question I think my Lady Simler asked me, the difference between the approach adopted in Phipps, the difference between the approach adopted in this case and Mohammed in our submission is quite clearly the fact that there is a need to consider the circumstances of the breach, and that breach itself per se is an important factor that potentially results in exclusion. And that is simply not the approach that was adopted by the Jamaican courts. Now, what we've sought to do, though, one of the issues that potentially arises from Mohammed, and it's one of the reasons why we've gone further in one sense and looked at JC, the Irish authority, is this. One of the difficulties in practical terms we would submit for a trial judge faced with a Mohammed argument is that, as with any balancing exercise, it can be very difficult to work out what weight should be attached to a breach of the Constitution, what factors are particularly important. And that's important because the temptation will always be to admit something because it seems of importance. There's an understandable reluctance.
Need a gift for your man this holiday? Meet the $100 Japanese-inspired knife. I heard the company is running a sale.
Exclude evidence that potentially is important evidence of guilt. But the risk of that in the long term is that that weakens the constitutional protections. Part of the point of Mohammed is that breaches should have consequences. If they don't have consequences, then the Constitution is undermined. And JC in our submission, one of the reasons why JC is important is because JC is based on similar idea. It's based on the idea that there needs to be a balance, but it's an attempt to give, in one sense, greater clarity. And the Irish Supreme Court expressly recognised the importance of clarity, because clarity means that the consequences of breaches are foreseeable. It means that the incentive essentially to breach is less. And that incentive, I mean, minimising that incentive is important. It links in one sense, thinking about it, to a point, again, that my Lady Simler made to me a moment ago, which is, wouldn't this material in any event, paraphrasing, wouldn't this material in any event have been admitted? If it would have been admitted in any event, the question immediately becomes potentially, why was the shortcut taken? The police knew about FIPS. Why were they taking the shortcut if they could have obtained this material in any event? And that's one of the reasons why it's important to have clear guidance, because police officers in those situations need to understand what the consequences of their actions are. JC is in the authorities bundle it's in the bundle at 6641. And we submit it is of significance for a number of reasons. Firstly, the Irish Constitution, obviously, like the Jamaican Constitution, represents decisions by a relatively newly independent state as to what rights should be given particular protection. Secondly, and if you need a reference to this, it's in the judgment of Mr. Justice O'Donnell at para 97, page 6670.
Sorry, paragraph
97.
Thank you.
Like the Jamaican Constitution, there is no express rule dealing with the exclusion of evidence. So what the court was trying to look at was what should be the implied rule, effectively. Now, what there is within the Irish Constitution, if you go to paragraph 4.18 of the judgment of Mr. Justice Clark, which is essentially the lead judgment on the approach to be adopted at 6686, there is an express obligation on the state to vindicate the rights of the citizen as far as possible. So there is a positive duty on the state essentially to protect rights, a factor that was relied upon. Here, we've already made the point about the language, particularly of section 13.1 of the Charter, which in our submission does impose, perhaps unusually in a human rights context, positive obligations on the Jamaican state to promote rights. Not only that, the Constitution includes a right to adequate redress. I took you to the provision, I think it's section 19. And it makes, sorry?
Redress for what?
For a breach of the Constitution.
Of whose? I might imagine redress might be for the breach of the constitutional rights of the person who was seeking redress.
Well, yes. I mean, obviously that's an important.
Can anyone seek redress for a breach of anybody's constitutional rights?
Well, in our submission, anyone can enforce those rights because of the first point I made, which is about the need
to do in these proceedings.
Sorry?
That's what you're seeking to do in these proceedings.
Well, that's what. Yes, because we're yes, because that well, it goes back to the Muhammad.
Not all constitutional rights that were breached on any view. It's not the rights of Mr. Jones and Mr. Sir John.
That's.
Oh my gosh! Okay.
Well, there clearly were issues in relation to one of the defendants, but as constitutional rights, because there was data in relation to one of them. But
Mr. Campbell.
Yes, Mr. Campbell. But the more important point in any event is that what this case law, what Muhammad it recognises is that, and this is made even perhaps more expressly clear by the Irish Supreme Court, is that if the courts simply ignore breaches of constitutional rights, then there is then the problem is that there's no incentive essentially on the state to comply with them, or there's very little incentive on the state to comply with them.
But Muhammad was dealing with a breach of the defendant's constitutional rights in relation to obtaining a confession.
It was dealing with a breach of his rights, but it was referring to but it was referencing the importance of breaches of constitutional rights generally. It was referencing the need to uphold the standards of the Constitution, and it goes back, if you consider the Jamaican provision, and it's why I started with it in one sense, Article 13.1 makes it clear that it's a positive obligation on all parts of the state, essentially, to promote human rights, to another way of phrasing that would be to not turn a blind eye to a breach of human rights. And that's, in our submission, what Muhammad is concerned with. I mean, if you think about the facts of this case, you had, on the evidence that you've got, the police were aware of their obligations following FIPS. You had individual officers who clearly were aware of their need to comply with Section 16. On the face of it, at the very least, they didn't investigate whether they were complying with Section 16. That, on the face of it, is a breach of the Constitution, and yet, on the approach of the Court of Appeal and the trial judge, that has no consequences. What's in one sense to stop police continuing to adopt a procedure which is clearly in breach of the Constitution. And that's why in my submission the point that that's made by the Irish Supreme Court about there needs to be a sort of clear rules to ensure compliance with constitutional rights is important in my submission. Lord, given time, I'm going to try and speed up a little bit, but just to be clear, the approach of the Irish court is based on the features I've drawn attention to, and based on also the need for consistency in approach, which you see at 4.16, of the judgment. It's to set out essentially a clear set of rules that you see at paragraph 5.1 onwards of the judgment. They are said to represent, see paragraph 4.22, the need to balance the encouragement of enforcement agencies. It's at the bottom half of paragraph 4.22. The need to balance compliance with the value of the evidence, essentially. And that compliance is important in my submission because, as I say, if there's no weight given to that factor, there is nothing to stop the police continuing to effectively ignore the FIPS ruling, ignore their obligations under the legislation, and simply and breach privacy rights. Now, what the Irish court does, and I'm just going to go through it very quickly, is it sets out a clear set of tests that focus essentially on the degree of culpability. And that's, we would submit, consistent in one sense with Mohammed, because Mohammed recognises that the nature of the breach is important. What it does, though, is give greater clarity to the nature of the relevance of the nature of the breach by focusing on whether it was a deliberate breach, considering the role of senior officers at paragraph 5.9, and then also considering the potential significance of negligence or recklessness. Given time, I'm going to, because I want to spend plenty of time on the jury point, I'm not going to go into JC in any greater detail, but clearly, had the JC approach applied in this case, and we make further submissions in our written case as to why JC should be followed. In our submission, if the JC approach had been followed, the prosecution simply couldn't establish why there hadn't been leadership, essentially, that ensured systems were in place to avoid this. And that, at the very least, we would say is gross negligence.
If it had been followed, the prosecution could not have established what?
The prosecution, sorry,
My name is Rachel Nelson. I'm a Term 5 School of Medicine student, and today I'll be visiting the General Hospital as part of my clinical training.
Had been followed, the prosecution couldn't establish why there were systems in place, what legitimate reason there were for not having systems in place that ensured compliance with the Act, in circumstances where they'd already known that there was an issue following FIPS. And that, at the very least, we would submit is gross negligence. On the face of it, nothing appears to have been done following FIPS.
And you say that would outweigh the balance on the other side?
Yes, because otherwise this is a case.
No, I understand. I just wanted to be clear.
Absolutely.
Outweighed the public interest.
Absolutely.
Yeah.
That having been said, can I just add one qualification to that, which is that, I mean, in one sense, that the way in which that would potentially come into play would be if the court is considering applying the proviso, and there would be in our submission a potential, if the court was effectively thinking of rejecting on that basis, there would potentially be a value in having a retrial on that issue because of the value of, in one sense, the correct approach, the weight to be given to the constitutional breach might be an issue for the Jamaican courts. I'm not inviting I mean, ultimately, we submit that the appeal should be allowed, but I'm just looking at, in one sense, a hypothetical example where, or a potential outcome, which is the court coming to the conclusion that the test was wrong, but the correct test would have made no difference. And I just would add a note of caution about this court. If it's a balancing exercise which has to give weight to non-compliance, question mark really whether this court's in the best position to assess that, given the importance of, in a sense, local assessment of the importance of the Charter. Can I then turn to the jury issues? A couple of preliminary points about the jury issues. Firstly, it is in our submission important to consider the jury issues together. In part, although we would say that any of the individual jury issues are sufficient for us to succeed, in part because if we're right that ultimately the question that this court has to ask itself is whether the fair-minded bystander would conclude there's a lack of independence and impartiality, everything to some extent comes together because it's ultimately the final position that was reached. Was that verdict reached by a body but which by the stage it was reaching its verdict was independent and impartial? And that's a reason potentially for considering everything together. And they do link in one sense, because obviously one of the concern, you'll be aware that we make submissions about what's described at times as the second incident, which in one sense for our purposes is actually the first incident, which is the juror who was discharged. But of course the juror who was released from the jury, one of the reasons that is of potential relevance is that seems to put pressure on the trial judge because he can't release any more jurors. And that's where he gets into this difficult situation where he knows that there is a juror who is attempting to bribe members of the jury, but they are allowed to continue to serve. Had they not been allowed to continue to serve, then the jury would have had to be discharged because of what had happened the second time.
So there were three incidents. I don't think you're making any submissions in relation to the first.
No, exactly. That's why I was saying.
So we refer to incidents 2 and 3.
2 and 3. I was going to use that language, but I was in one sense, in terms of what we're arguing, 2 is 1, but that's where the slight complication came from. But yes,
we're better stick with 2 and 3.
I wanted to make clear. I wanted to make sure everyone was using the same language in that way. Yes, absolutely. The second thing is that, in particular, in relation to and it's important not to lose sight of this when one gets into the detail, in relation to, in one sense, that the third incident in particular, the Crown puts very heavy weight on the directions given by the judge. Now, I'll make some submissions about those directions. But there is a fundamental problem in our submission by the time of the third incident. By the time of the third incident, the judge is proceeding on the basis that one of the jurors has attempted to bribe the other members of the jury. He's committed, potentially, a very serious criminal offence. And we, in fact, know he was convicted of that serious offence. And indeed, he was arrested immediately after the verdict.
J.D. Power now ranks Sleep Number #1 in customer satisfaction with mattresses purchased in-store. Visit sleepnumber.com to learn more.
There's one simple sugar hack anyone can do to balance glucose levels almost overnight. Did you know that type 2 diabetes?
While it may be right to assume for many jurors that they will comply with directions, if someone has demonstrated that they are willing to commit a serious criminal offence in the context of this trial, how can one then rely on their compliance with directions? It's unrealistic in our submission in those circumstances. And that's an important factor not to lose sight of, because it, in one sense, one can get wrapped up in the weeds of what happens, and it's important to go into the details, but one shouldn't lose sight of that overall problem, and it's a very significant problem in our submission, and it's just an insolvable one. It may have been deeply regrettable in Jamaica that a trial that has gone on for so long had to be restarted, but ultimately, if that's what's required to ensure that the trial is fair, then that's And that's what's required.
There's nothing in Jamaican law that allows a judge to continue as judge alone without a jury.
No. And my lady's raised that point, and we sort of thought about it, and obviously there is now in English law, it's a relatively recent development.
Yes, when there's jury tampering.
When there's jury tampering. And if jury tampering is a major problem in Jamaica, in one sense, that's the solution. The Millennium Friend says, I'll come on to those submissions, you can't allow someone effectively to derail the trial. But if derailing the trial is a serious problem in Jamaica, well, there is a solution that's been adopted in England but hasn't been adopted in Jamaica.
And it's paragraph 31. We fully understand any judge's reluctance to discharge a jury in circumstances for which a defendant bore material responsibility, although there are no doubt gradations of responsibility, starting with deliberate misconduct by a defendant aimed at achieving a discharge in circumstances where a trial is going badly, or at achieving a favourable verdict and ranging downwards in seriousness from those situations. Counsel for the appellant thus, rightly in our view, accepted before us that it cannot be open to a defendant to obtain the discharge of a jury by deliberately creating some ground of aggravation or discord between him and the jury, whether inside or outside court. But in order for a judge to rely on the appellant's responsibility for events occurring as a ground for not discharging a jury, the circumstances giving rise to such responsibility must, it seems to us, either be agreed or ascertained by the judge to exist. They cannot be assumed simply that it's a prima facie case. Now, that's not on all fours, but I submit the basic point is this. It's not open to either a defendant himself or indeed a juror acting, if you like, without instructions from the defendant, but nonetheless in the defendant's interest to derail a trial. And I submit that's an important point, and I submit it also goes to the whole jury system. And it will bring the jury system into disrepute in a case such as this. If the position is really this, there are 10 innocent jurors who have performed their duty, let's assume for the moment, who have performed their duty without any shred of bias. It would bring the system into disrepute if the verdict is nonetheless to be set aside because of the one bad juror who was not obeying his duty. I submit that would be, one can understand what you might call the purest version of that. One can understand, of course, the notion that a jury has collective responsibility. But in my submission, that would be would strike, I submit, what you might call the man in the street, the sensible man in the street, as a remarkable result.
But the normal scenario would be that, of course, you get rid of that juror.
I agree. The difficulty here...
I mean, you wouldn't say, well, you can carry on with that juror.
But I think, my lords, I'm bound to accept that we don't know, of course, but obviously what concerned the judge is, I don't think I took you specifically to it, but he does at one point say, what am I going to do? Either I let the juror out, in which case the case can't continue, or it carries on. I accept what your lordship says, but my lord, again...
What I'm saying is the quote from paragraph 31 leads us to the obvious result that, of course, a juror who's refusing to obey directions has to go.
He has to go. Well,
that doesn't then follow that, oh, you can leave him on.
No. Subject to one point, what I call the waiver point. And the prosecution here, it is, as they pointed out, they're the losers in this. You know who was the one. I don't think there's any doubt about that. And that was a matter of witness evidence obtained by, funnily enough, the defence afterwards.
Yes, but
But if it's a, well, I think the point that her ladyship is making is that one doesn't know how people may react to an attempt to bribe them. If a jurors thought that an attempt was being made to bribe them on behalf of the defendants, then that might have, who knows, it could have inclined them to dig their heels in and prejudice them against the defendants. My Lord, I agree. That of course, is the second question. I'm just on the first question for the moment. Can I, namely, there was just a rotten juror. Does that of itself mean the verdict cannot stand? And can I give you an example where I submit it is not of itself a sufficient reason? Supposing what happens is this. A jury comes in with, let's say, a 10-1 verdict. The one has been bribed, but the one has not revealed that to anyone else. It all comes after the trial. Can the defendant come along after and say, oh, dear, there was a rotten juror on that, he didn't tell anyone about it, but nonetheless the verdict must be set aside because there was just one, as well, there was one person who wasn't performing his duty, qua juror. My submission would be that would receive short shrift from the appellate court. It would say, well, the rotten juror didn't speak to anyone, he didn't obey his duty, he did come in with a not guilty verdict because he'd been bribed, but on the other hand, that made no difference whatsoever to the 10 who did come in with a guilty verdict. We know it didn't, because he didn't even mention it. Now, in those circumstances, I submit the verdict would stand. And I simply give that as an example as to why what you might call the pure point, there have to be 11 good jurors, even when there's a 10-1 verdict and the 10 are good. There have to be 11 and the whole thing falls to pieces. Cannot be right. And I submit that, in the example I've given, that would give rise to very considerable public concern.
But the trouble is, we don't know.
I've got to have that.
We're not supposed to know.
Well, I know we're not.
Who's saying what in the jury room? So you can never. So the hypothetical you're given can never arise in reality.
Well, my lord, I hesitate to disagree, but I would say that it could arise, and indeed, in this case, we do know precisely what happened. Yeah. I mean, supposing Livingston came, for whatever reason, supposing he had not mentioned any of this to the jurors, but afterwards it came out that he had actually received bribes and was convicted. But let's just say, or he had received bribes from one of the defendants. So it's not on all fours, but I'm simply at the moment on the point, do there have to be 11 good jurors, full stop? And if there's one bad juror, the whole thing falls away. I submit that's not right. The other question is the different question entirely, namely, what about the juror, the 10 good jurors, saying to themselves, well, you know, obviously, they're all bent, these people. And so I'm going to hold, it's a sort of little bit of prejudicial information which they're holding against the four appellants. That's the question. Now, my respectful submission on that is, as well the second part of the question, is this. The question is, was the judge bound to assume, in all the circumstances, that whatever directions he had given, or could give, was he bound to assume that the taint, if I can put it that way, of the bribing juror was never going to leave the minds of the 10 good jurors, such that, maybe even unconsciously, they would hold this against the accused?
But isn't that the wrong way round? Doesn't he have to be sure that there isn't that risk, rather than the way you've put it?
Well,
he has to be sure that there won't be, that justice will be done, yes, rather than the other way around.
My lady?
I'm trying to...
Yes, I'm bound to accept that. I maybe have too many double negatives in what I was saying. I accept he has to satisfy himself that he is in a position, given what he's already said and will say, to ensure that there will be a fair trial for the other appellants. Yeah. That's the question. And in my submission, it's a question of fact to an extent, but on the facts, I submit he was entitled to come to the conclusion that the 10 jurors, with proper directions, would not take into account the fact that one of them had been offering bribes. And that, in my submission, was obviously a matter for the trial judge himself to assess, and that's how he assessed it. And my lords, my lady, I also rely on the fact that the Court of Appeal upheld the judge's judgment on this point. So what you would be effectively doing is saying to the, as were the local courts, they were wrong to hold that justice, there could be a fair trial, notwithstanding.
But the Court of Appeal appears to have been comforted by the fact that there was nothing to be gained by questioning or looking into the matter any further. At best, a denial of bribery, and a great deal that would have been lost, the possibility of having to discharge the whole jury. Was that the right approach?
Well, my lady, I think one has to bear in mind what was being put to the Court of Appeal. I think from recollection, what was being said to the Court of Appeal, and is not so much being said now, is that the judge should have carried out an inquiry. He should have made more inquiries. My answer to that is that if the judge was satisfied that a direction would put the matter right, then he was entitled to take that course. I agree. I agree. The question is, could he rationally be satisfied? You might say if he couldn't rationally be satisfied, well, that's that. But in my submission, he could be, for the reasons I've already, in a sense, gone through right at the beginning. He has reminded the jury of the seriousness of their role and the importance of deciding in accordance with the evidence. He's told them again and again, you are the judges. You are not to speak to anyone. They are well aware of their special position. And I submit it's quite often the case that prejudicial information comes out in the course of the trial, which gets in front of the jury. And as long as a judge's direction, I'll come on to the direction in a moment, as long as a judge's direction is sufficient to ensure that the jury will decide in accordance with the evidence and not in accordance with the unfair prejudicial material, then he's entitled to take that course. And my lords, my lady, obviously one can well understand, of course, the concern in this case. Of course, that it might be said, well, who could forget? But my lady, my lords, I submit it's not that difficult. Jurors have to be trusted to act in accordance with their oath. I want to take you to a case about that. It's a cardinal principle that jurors do act in accordance with their oath, and they act only in accordance with the evidence. And if I may, can I take you back to the case of Bonnet, where Lord Hope makes this point, and he refers to other cases of higher authority, which say the cardinal principle of jury trial is that jurors act in accordance with their oath. They're not nincompoops.
Can I just ask you, in the context of your submissions, do you see any role for the Porter and McGill test?
It's fair to say that where I'm putting it is that the question is whether there was a fair trial or not. And in my submission, if one could be satisfied that there was a fair trial, that is that. I mean, in one sense, I accept that what I'm saying is that if the court is satisfied there was no risk of well, in one sense, Porter and McGill is to do with a real risk of possibility that the tribunal is biased. But it's not the appearance so much, but there is a risk of possible bias. And to that extent, I accept Porter and McGill is right, because in my submission, what the judge did was to remove any risk of possible bias. It's not quite the same way as the Putnam test, but it comes to much the same. But appearance of bias per se, I submit, is not the relevant test. The question is, was there a real risk of possibility of bias?
And you say he removed that by the direction he gave at 3:22?
And also by what he'd been telling them before. It's the whole thing has to be looked at. It's often said in the cases that the judge is entitled to look at, the judge in making these sorts of decisions will bear in mind his view of the jury, so far as he can tell, over the course of the hearing. And in my submission, he was entitled to take into account also what the forewoman had said to him. And I do submit, if one asks, and looking at everything, if one looks at A, the verdict, B, the letting off of Shane Williams, and C, the evidence, which I'll come to later, which is simply overwhelming, one asks, what unconscious bias, so to speak, added to all the evidence which was there anyway? How could it have done? And that is the point about the strength of the case. One can see where the evidence is equivocal and so forth. One might say, well, that's rather harder to tell. But if it's 2 and 2 equals 4, well, there is in my submission a basis for saying the risk of the possibility of bias it has been removed, was not likely to have affected the jury's verdict, or won't have affected the jury's verdict. Can I just take you to the Bonnet and Taylor case? It is important, this point, to what extent can you trust the jury to act properly and in accordance with their oath? And we looked at one passage already. It's at 6291.
Simplicity from a credit card? That's unexpectedly human. The all-new TD Clear credit card.
With 6290, one can begin at, paragraph 24. There was, however, another course that the judge could have taken, and did take in this case. That's to say, not making further inquiries about the juror. At the outset of his summing up, he gave the usual direction to the jury. It was for them to decide what evidence to accept and what to reject. He then gave this direction. Decide this case on the evidence and only on the evidence. Do not be influenced by anything you might have been told by anyone, whether by some fellow member of the jury that sat or are sitting with you about some prior knowledge or feeling or view. That is unimportant. And if you act upon that, justice will have miscarried because that's not the evidence. I hope that I'm making myself absolutely clear that it's the evidence and only the evidence in this case that you have heard that you're entitled to act upon and determine. Having looked at the evidence, examined it, weighed it, determined what facts are, and ultimately what your verdict is after applying the law. And I will give you to the facts that you find proved. Now, I agree that's a stronger warning, but nonetheless, it's to the same effect. Then, the important passage in paragraph 25. The assumption must be that the jury understood and followed the direction that they were given. See, a judgment of my own, as it were. In the Supreme Court of Canada, in Corbett, Chief Justice Dixon said that the experience of trial judges is that juries perform their duty according to the law. In the High Court of Australia, in Denham, Mason CJ and Toohey J said that the law proceeds on the footing that the jury, acting in accordance with the instructions given to them by the trial judge, will render a true verdict in accordance with the evidence. To conclude otherwise would be to underrate the integrity of the system of trial by jury and the effect on the jury of the instructions by the trial judge. In the Irish High Court case of Z, Hamilton P. expressed confidence in juries to follow the directions given to them by the trial judge. The direction which the judge gave in this case was clear, understandable, to the point. The board is satisfied that it was sufficient to deal with any risk that the juror who was excused might have said something that the jury ought not to have been told. Now, of course, my lord, everything turns on the facts of a particular case, but I do submit it as a fundamental principle that you trust the jury to act in accordance with their oath. And it is implicit both in the judge's decision to leave this matter to the jury and in the Court of Appeal's decision that they were satisfied with their knowledge, if I can put it this way, of how juries work, that they would have done.
And does it matter that, inevitably you're focusing on the 10 because he didn't trust the 11th. He had the police ready. He said he had the police ready.
I accept it. That goes back to my answer to the first part. I accept he probably
doesn't. Does it matter for these purposes that it's effectively he's trusting a jury of 10,
yes,
and 10's not a jury within the Jury Act in Baker, is it?
one then gets into what I call a rather metaphysical argument about what is a jury. Clearly, it's 11 people who walk into court. About that, I go back to what I call the first question. Is it really the case that there is no jury if it turns out afterwards that one of them had taken a bribe and was going to acquit come what may?
That's if it turns out afterwards.
Yes.
What if you know going in?
If you know going in, I submit the same follows. The judge is entitled to say this: a 10-1 verdict is a good verdict. It's authorised by law. I have good reason, I'm just, as it were, expressing in words what no doubt the judge would be thinking. I have good reason to trust the 10. They will follow my directions. That is good enough to satisfy the requirements of the statute, that there be a jury who decides this. Because there are 11 altogether, and if there are 11 altogether and one of them still takes no notice of what I say, well, so be it. But my Lord Lord put the point at the beginning. It's quite a short point, but quite an important point. But I do submit that the crossover between these two questions does arise, but I suppose it's very important to keep them separate. Because if I'm right in saying that a verdict by 11 men, or 11 men and women, one of whom is bent, is a good verdict at the time, then it's a good verdict. If, on the other hand, it's clear that there's a real risk that the 10 might have been influenced by the one, then I accept. That might be a basis for setting aside the verdict.
Just starting with the one, you say that the judge can choose to leave somebody on the jury, notwithstanding that he knows this person is corrupt. Presumably, it's the same if he knows that the juror is mentally ill or communicating with the deceased via a Ouija board or has been looking up the internet. It's the same, is it?
No. No, my lords, it wouldn't be the same. If I may, no. The important point here is the prosecution knows the problem, and in the passage I took you to, the prosecution says, we're the ones taking the risk.
Well, but they can't waive the public interest in the administration of justice. It's not a matter...
Well, the difficulty, my lords, if this had happened on day one, it would be a very different position, obviously.
Well, you're really just postponing the question. So on your view, can the prosecutor decide that it's okay to allow somebody to remain on a jury, notwithstanding all the scenarios that I've put to you, and the judge can go along with that?
In my submission, in the extreme circumstances of this case, yes.
And how many jurors can the judge allow to remain on the jury, notwithstanding his knowledge that this one's mentally ill, that one's been bribed, the next one's in touch with the deceased via a spiritualist?
Well, no, of course, he can't. The whole problem in this case arises because there were just 11 left. That is where the problem arises from. And my lords, of course, I can see one can think of any number of examples, like the Lordship is putting it, saying, for those circumstances, surely the prosecution couldn't just waive it. But this is rather different. This is right at the end of the trial, enormous expense, 56 days, the evidence has all come out, the summing up has been done, and then boom, one thing comes out. Now, in my submission, the question is simply this. I mean, it does get to this point. If I'm right in saying that a verdict of a 10-1 verdict of 10 good people and one bent person is a good verdict as a matter of law, then the judge is entitled, and the prosecution is entitled to say, well, I dare say that person won't obey his oath, but I'm satisfied the other 10 will.
But that's assuming there's going to be a conviction. And the jury has, if it's going to acquit, is going to have to do it by, is it an 11-person jury is going to have to do it by a 10-1 majority. And how does the court, the judge know? Well, it's likely that there will be 9 good people and true and 1 crook in the 10. It's an acquittal.
Well, my lord, if in my submission, the judge, the fundamental right is to a fair trial for the defendants. If the prosecution, and in one sense, this whole case comes down to one point: can the prosecution say, I know there is this one person who seems to be offering bribes. We probably can't trust him, but I'm prepared to carry on and take that risk. Is it open to the prosecution to do that? That is the question. That's what the prosecution did. And in my submission, the answer is yes. There's no authority, if I may, with great respect say, that says, no, the prosecution cannot do that, because that would deprive the accused of an unfair trial. I also make this point. The question is not, so to speak, at the very moment this all takes place, but looked at broadly, looking at that verdict. Have the defendants received a fair trial? If one is satisfied the 10 were not influenced. I agree, obviously, that's a separate question. But assume for the moment that the 10 applied with their oath, they acted properly. Is it really to be said that that was a bad verdict and the defendants must be acquitted or the appeal must be allowed? I submit no. That, I do firmly say that would bring justice into disrepute. 10 people have done their duty, one person has messed it all up, but the verdict is a good verdict at 10-1. Why does it matter if the one has brought disaster? That brings the jury system into disrepute. My learned friends, of course, rightly say that in England we don't have that problem. But this is a common law point. And the question is, what is the common law in this situation? And that's why I urge upon your lordships the point that I'm making. I fully accept you've got the separate point about who knows what was going on in the back of the jurors' minds. That's a different point. But my point is just on this, what you might call the degree to which there have to be 11 people on the jury. The fact is there were 11 people on the jury. That is my short answer to this. One of whom, at the time, there was good reason to suppose wouldn't act properly, and who we now know didn't act properly. I submit that's not a conclusive answer. And
Can I just take you to, I mean, where we got to, I think, which was paragraph 25 of the Bonnet-Taylor decision, page 6291.
Yes, thank you.
Lord Hope very clearly says that the direction which the judge gave in this case was clear, understandable, and to the point. And we look either earlier at what was being put forward as the defence, as the direction.
Yes.
You know, don't allow anyone that you sat or sitting with about some prior knowledge or feeling or view, that's unimportant. In other words, he's directed the jury to the specific problem. Now, just to say you've got to carry on with your oath seems to me non-specific. It is not to the point. It doesn't make clear to the jury precisely what the judge is wanting them to do.
In my submission in this context, it does, because they will all know there's been this half-hour break in the summing up. While form has been called away, she will have told them, because the judge says, tell the others, she will have told them what's happened. And my lords, I fully accept, of course, one might say the direction could be more forceful, I accept that. But the question is, was it sufficient to ensure the fairness of the trial, given everything else which I've mentioned? And in my submission it was.
But all I'm saying to you, putting to you, not a specific direction.
Well, my lord, not express, I don't want to, as it were, quibble. I accept it was not specific, and of course, it would have been better were it this specific. But the question is, was the direction given by the judge taken together with everything he had already said, and the juror's sense of responsibility, was it sufficient? But of course, this is a different point. My submission is it was, in one sense. I take your lordship's point. It's not specific in the way this was, but in my submission it was sufficient.
I'm not sure that it. I think you probably have dealt with this point, but it strikes me. But when you say this is a question of common law, I don't think it's purely common law, because we do have statutory provision.
Yes,
it's on page 6803.
Yes.
Which tells us that 12 jurors form the array in a case of murder, and then says in subsection 3, where in the course of a trial any member of a jury dies, or is discharged by the court through illness or other sufficient cause, the jury shall nevertheless, so long as the number of its members, so it's a proviso, so long as the number of its members are not reduced by more than one, be considered as remaining properly constituted. Now, it might be said that the judge, as it were, can't sidestep that provision by failing to discharge somebody where there was indeed sufficient cause to discharge them. If he discovered, for example, that the person, the person had been bribed, or was the defendant's brother-in-law, or whatever you like.
Well, in my submission, that wouldn't be the correct construction of this. In one sense, you have my point. As long as there are.
I mean, you were saying it's just a question of counting the number of live bodies on the jury, and
that's all it's saying.
Yeah.
My learned friends, my submission, that's what it's saying.
Yeah.
And my lord, after all, one doesn't know. I mean, at the time the judge gives his direction and decides what to do, he might be hoping against hope, so to speak, that the miscreant juror will actually just see sense.
Mm-hmm.
But it doesn't follow, in my submission, from this act that the judge is bound to get rid of that juror. That's the question. But I agree, if he's bound to get rid of that juror, he's bound to bring the case to an end for that very reason. And this is why it is a short point, but in my submission, a difficult and interesting point. I haven't addressed you on the proviso and things like that, but I'm conscious of the time. But I wouldn't mind showing you some of the evidence. I mean, it is, because I do connect it to my point. Well, there was no need for any, if I can put it this way. Anyone looking at the evidence would say, I couldn't care less about these bribes, so what? I've seen it with my own two eyes, type of thing. Forget the bribe.
Yes.
But I'm conscious, my lord, I'm praying on your time. I don't know how you want to proceed. I see what the time is now.
Well, obviously you have more time tomorrow. We perhaps, speaking for myself, the point you've made about how you could find out after the event that a juror was corrupt. And the question then is if the other jurors had voted 10-1 to convict, completely ignorant of the fact that would the verdict nevertheless be vitiated, and it would have to. And I think if it were, it would be on the basis that we've been discussing, that there is, as it were, a non-quorate.
Non-quorate point, really, yeah.
Which suggests it may suggest that the point we made earlier, the point I made earlier about based on. Seraphim may not be quite as obvious where you have 11 judges, as it were, as it is where you've got one judge.
As in that case.
Well, should we leave it there for the?
I'm so sorry. The case that you mentioned in Strasbourg about the racist members of the jury. Do you have the reference?
Mr. Turnbull has the reference. It's Gregory v. UK, page 7914. And I have a feeling there are two other cases which similar issues arose. Yeah. I cannot quite remember. If you give me one, sorry? Sander's one of them. Is there? And there's another one too.
There's a Russian case, which is not exactly on point, Tinkov.
Oh yes, there's the Russian case, that's right. Yes. At 373. 8373. Thank you.
Very well.
Sander is
sorry.
7960. Thank you.
Well, I think we may have reached a convenient point to adjourn for the day. We'll consider where we are in relation to the JS2 point ourselves, and we'll look forward to hearing the remainder of your submissions tomorrow, Mr. Knox.
I will back.